has been around for a very long time. Mr. Ansasari is our guest in the studio this morning. Sir, good morning, and thank you for coming.
And a very fine morning to our cherished listeners.
You still practice?
Yes.
I see. You still go to court?
Sure. I was in court yesterday. I'll go to court on Monday.
Where is the energy coming from? You're 70 plus now.
God. The Almighty.
I see.
Yes.
I know you've been doing
73 in a month's time.
7'3".
Yeah.
You don't look it.
By His grace.
We thank God for your life.
Thank you.
God for your life. A lot has been happening within our legal space in recent times. Sometimes for us, they say that our knowledge of the law is so limited. What we read is English. But when it comes to the interpretation, you are the rights people. Generally, what would you make of the legal space in Ghana? As an ordinary man, for example, if I have a case and the case ends up in courts, am I confident of getting a fair judgment in the courts?
Well, thank you very much. The answer will lie in it depends on the individual. Quite a number of Ghanaians still have confidence in the legal system.
Why shouldn't it be all Ghanaians?
Even in the advanced countries, it is not everybody who has confidence in the legal system. So it's relative. It's very relative. But to return to your question, as I said, the answer depends on the person you talk to.
Mm-hmm.
Those who obtain justice according to their own measurement have confidence. Those who go and lose their cases will not have confidence. So it depends. If you win, if you have your day in court, you have confidence in the system. If you lose, you don't have confidence in the system. But by and large, what goes on in the courtrooms and around the courtrooms, also have much, to say on this issue. Sometimes court clerks give the impression that they are in cahoots with the judges, and when in actual fact they have said nothing to the presiding judge, or that the presiding judge hasn't said anything to them, but they follow the proceedings, and they are able to predict the likely outcome of a case. So they can tell the parties and their witnesses that this will be the outcome of that case. But if you want to win, Ghana, if you want to win, give me something to go and give the judge. In 90 out of 100% cases, it is not so.
I see.
They have not said
But when
anything.
we see the photos, for example, and the videos of a couple of years ago, where in those videos we see that some of the judges accept as low as they go to decide on how a case would go, that should be worrying.
It has everything, to do with our culture. You see, in our culture, we pay obeisance to thank you. Whatever we do, we have to thank the person. So people voluntarily sometimes, make present. They give presents to judges. The judges might not have asked them for those gifts, but it is part of our culture. So the basic difference between a bribe and a thank you offering is this: if you demand or you request some money or some goods or whatever before you carry out or perform your function or obligation, it will constitute a bribe. And from the point of view of the bribor and the bribee, that's the person giving the bribe and the person receiving the bribe, see, they know it is a bribe. But they give in order, to smoothing the rough edges, of their cases. I'm not trying to justify that it is good to give. Then there are also those who wait until they know or the outcome, or the particular, case.
And then if it goes in their favor,
they
go and say thank
you.
you.
Go and render their thanks. Oh, why are they actually? And then maybe just to say hello, but I have something small for you. And then
should the judge accept that?
As I said, it's our culture. If you accept it, they say it's a bribe. If you don't accept, you are snobbish. Society will roundly condemn you. They'll talk, ill against you. So it depends. But all in all, if you read the Afrobarometer report, of recent, it seems that the confidence of our people in the justice delivery system has reduced by as much as 20 to 30%.
And I was going to get there.
Yes, that is, a bit worrying, and therefore, if anything can be done to dispel the erroneous impression that the perception out there is in fact a reality, where people will continue to have to lose confidence in the system.
But when you have such a large number of people in 7 years losing that level of confidence in the judiciary, doesn't it communicate a lot about the level of rulings that come out from our courts in recent times?
Partly. You see, when litigants are able to predict the likely outcome of cases, and they get it, the other party will conclude that the judge was bribed. It may not necessarily be so, but after all, the law must be certain and predictable. The law must be certain and predictable. It must be consistent. So if we are teaching our students, we'll tell them that one advantage of the precedent system is the ability of a lawyer to be able to predict the likely outcome of a case, to his clients. That if we go to court, this and this and this and this will be, the likely outcome. If it's a very bad case, what is of worrying concern is the all too predictable rulings that citizens can, just predict that if you take this case to court, depending on which part of the fence you sit on, it belongs to the MPP, then you lose the case.
To the political cases.
The political cases. And it is many more of the political cases, that are giving or lending credence to this all too predictable element that has, found its way into justice delivery system.
So, in line with that, a couple of weeks or months ago, there was a statement from the Minister of National Security, Mr. Albert Kandapah, someone I have known literally my whole life, saying that these kind of judgments, unfortunately, put out a certain perception, and it could be a worry going forward. If you have a Minister for National Security passing comments like this, doesn't it call the work of the judiciary into question?
It does. And when the Honorable Kandapah made that pronouncement, there were people, in the MPP who thought that he shouldn't. You see, one of the problems we have had in this country is that when you speak truth, they or label you and give you all sorts of names and this thing. We don't like speaking, truth. But my point of view is that truth will never terminate. No matter, the position, truth will always, prevail. So it never terminates. So if the minister who hears everything gets to know everything, expresses himself the way he did, it must be worrying. You see, and then, but it is not peculiar to the MPP government. It is something that has, that has simmered right from attainment of independence on 6 March 1957. The way you give a certain judgment that is unpalatable to an incumbent president, there's a way the judge, will give a verdict, let's say, while sitting at Koforidua High Court, and then the judgment goes against some people in the corridors of power, and the next day the judge is transferred to Soutium. The name Soutium, for instance, if you're a judge in Accra, and because of a certain position you have taken on a case, you are transferred to Soutium. Soutium, literally meaning hold your ground. Next time, would you give an identical or highly similar ruling or judgment? You will not. You see, so that is what.
But why should the who does the transfers? For clarity, who does the transfers?
The judicial secretary, but it will be upon the instructions of the head of the judiciary, and according to our constitution, the head of the judiciary is the chief justice.
Okay, so you decide on a case as a judge, and because it is very political in nature, you get a letter or you get a call, or I don't know how your transfers are done. I'm sure it's a letter.
You may even offend the head of the judiciary.
Exactly, depending on how the ruling would have gone.
And you may be transferred from Accra to Hokwe or Tepa or Goso or even Latte.
But the person is only doing his job.
Yeah, but again, when you offend someone's sensibilities, there's a way our leadership reacts to certain judicial pronouncements and decisions. You see,
like in the case involving Chachu Chikata, when the first ruling was 5-4, and then the president decided to nominate Justice Afenyo and someone else to overturn that particular decision. Is that proper?
Yes and no. It wasn't proper, because if you did that, you'll be perceived as attempting to pack the court. To pack the cause, so as to overturn. So the Chachu Chikata case, for instance, is one of the cases that, will forever remain a scar on the conscience of the nation. A scar because it's a blot. People believe that the court was packed, but it is not every judge who will agree to be elevated so as to lend credence to packing other courts. Some judges have declined to be elevated. For instance, I know for sure that the Honorable Lady, former Lady Chief Justice Georgina Wood, when she was invited, she declined. It was published
with respect to that particular case.
Yes, I mean, it was reported Justice Brobe declined. But the reasons they gave, we have seniors. Let the seniors go. So Afre happened to be, one of the most seniors, and I
ostensibly to overturn the decision.
Not ostensibly to overturn. That is the perception out there. But
there was a ruling. You leave it at that. Why do you add on to the judges to overturn the decision?
Yeah, but when the Supreme Court rules, there are certain windows left open, so you can go for a review and then another review. So from time to time, the Supreme Court itself lays down or formulate guidelines as to when you can ask for a review, in order to dispel this erroneous perception that any addition to the 5 or the 7, but procedurally from 5 you have to go to 7, from 7 you have to go to 9
to 11,
9 to 11, and on each occasion fresh hands, fresh heads, fresh ideas. Therefore you need many more than the starting line of 5 or the 7 or the 9 or the 11. Either way, the perception will be there that the court is being packed. So it depends on the approach of the incumbent government and in this instance the president to allay the fears of the public the unsuspecting litigating public, anything you do will amount to the packing of the court.
So let me have a look at this, and I believe you're in a position to speak to this. In the US, there are 9 members of the Supreme Court, and they are in office till they die or they resign. So it's 9. Per our constitution, do we have a specific number?
We don't have. It's if you look at Article 128, it says that the Supreme Court shall be composed of the Chief Justice and not less than. So there's no ceiling. The Chief Justice and not less than. If it has said not more than, then it will be pegged. But it says not less than, so it's ad infinitum.
We have 15 at this point, and 2 are going to be added. Okay, one just retired last week. So
I understand Mariama, retired last week. So
yes.
After
the ruling. So I'm told another one is in line to retire. That's why the 2 are going to be added onto our 15. Does a country like Ghana need 15 Supreme Court judges?
It depends upon the leadership. You see, I can predict what is going to happen in the US. Trump is likely to increase the number from 9 to maybe 11 or 13. Every generation has got its own leadership problems, you see, and what Trump is likely to do to the judiciary in the US is bound to have negative and positive effect or impact on our courts. You see, we tend to copy blindly. You will say even in the US they are increased, but you were right from when the US Constitution was promulgated up to now.
They've been doing 9.
They've been doing now 9, and the 9 has worked perfectly for them. But recall the way and manner Trump invited and elevated some people.
Yeah, there were vacancies and he replaced them.
He didn't.
Yeah, because they held on to his nomination at the time.
Exactly.
Holder, I think that was his name.
Yes.
The Senate could not give him a confirmation hearing. But under Trump, he was able to get at least 3. Justice Kavanaugh, Justice Gorsuch, and then there's one I can't readily recall.
And he's going to, to do more.
If there is a vacancy. If there is a vacancy.
I can predict that the if will not be there. He will do it.
I'm asking this because in our case, we have 15. And what has come up in recent times, especially in line with these issues in Parliament, is that it appears that some of the appointees to the Supreme Court are political in nature. So once they get there, on the back of the party that put them there, when there are issues, you are more likely to see the case ending up in a certain direction. So I've seen, for example, people refer to the Supreme Court these days as unanimous FC, because it looks like almost every political case that goes there, that the government has already won, and sometimes it's going to be 7-0, 9-0, whatever 0. Should we continue to have a situation where the president will nominate judges onto the Supreme Court and even nominate the Chief Justice?
I think that the practice should come to an end.
How do you mean?
This particular government has created a problem for the nation,
which is
with the approach to nominating persons, onto the Supreme Court. You see, the procedure as at independence was that the justices, were appointed by the Judicial Service Commission established at independence. So it was one of the institutions, one of the statutory institutions that was put in place to insulate the judiciary from
political influence.
Yeah, political influence. But if you go back to history and see what Kwame Nkrumah of blessed memory did when it came to appointing persons to fill vacancies occurring on the judicial, you see that he sort of abused, the system.
Yeah, that was all of those years ago.
Yes, but
we could have corrected it.
That is the history. That is the history. But the worst breaches have occurred under the current president. And I find it all the more worrying because the current president is a lawyer and knows that, as a lawyer, whatever he does must be in the defense, of the constitutional safeguards, when it comes to appointing persons to fill. But when the current Chief Justice was nominated and I was interviewed as to what my thoughts were, the remarks I remember, my introductory remarks, to the effect that I hope it will be the last such appointment when a junior will be nominated over and above seniors.
When you say junior, what do you mean? As in her number of years at the bench?
The number of years and the fact that they are already sitting justices of the Supreme Court. So if you plug somebody from Court of Appeal to the Supreme Court and within 2 or 3 years the person is appointed Chief Justice, the seniors will not like it, but they cannot voice their irritation or resentment or anger. They can't, by virtue of their positions. So they are injuncted from making any pronouncement. So country broke or country no broke, we dey inside.
So you advise that the most senior.
So I'm suggesting that the current Supreme Court must sit, whether they are 15 or 20 or all of them must sit and try to interpret Article 146 with regard to filling of vacancies and remove the words until a person is appointed. When the words until a person is appointed are removed, it will be when a vacancy occurs, the most senior shall be appointed to fill it. Finished. We won't have any problem again.
Madam Chief Justice, Madam Torkonoo is 61.
It's not the years, but the standing at the bar.
No, I'm looking at if we're going by what I know, she's 61, and the only time she would knock off is when she turns 70. So for the next 9 years, she'll be our Chief Justice. So if she turns 70 and she's retiring, you are hoping that the next senior should be giving the nod automatically, not an appointment coming from somewhere.
No, the next senior, the next most senior Justice of the Supreme Court
at the time
should
be given the nod.
Because when we are appointed, you know
who is first, second, third.
The last person will be at the at bottom. The most senior
at the top.
At the top. So So now, if you take the Ghana Law Report or the Supreme Court of Ghana Law Report, the position of the justices is indicated, so everybody knows. We all know
that this is number 1, number 2, number 3.
Who is the most junior? And you go to the law school, the director. If the director is absent, the most senior lecturer automatically becomes the acting director,
and not an appointment coming in from somewhere. I want us to wrap up the conversation with what happened in Parliament in recent times. For example, this issue with Article 97 G&H. I read the English. When I read the English that was there in the Constitution, I'm not a lawyer. My understanding of G&H was that the 4 members of Parliament at the time who had decided to leave, immediately they took the decision, and there was a notice of poll coming in from the Electoral Commission. G, if he leaves the party of which he was a member of Parliament at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. So joining another party was Andrew Esiama. seeking to remain in Parliament as an independent member were the 3 who had already been elected. If he was elected a member of Parliament as an independent in the case of the Honorable Esiama, and joins a political party in the case of the Honorable Esiama, it was clear to me, and I had no doubts in my mind, that the 4 had taken a decision that they knew would affect them.
Sure.
The case went all the way to the Supreme Court. First of all, should it have gotten to the Supreme Court?
No.
It should have gone to the High Court, we hear. Why?
Because that is what Article 99 says. Article 99 says that in such, a situation, it is only the High Court.
The High Court.
So if the Constitution has, mandated the High Court to handle such matters, it need not go to the Supreme Court.
Madam Chief Justice said the case would have come to them anyway because there was an interpretational issue there. That's what she said in court.
If the High Court judge felt that there was an interpretation, then we'll make a state proceedings. But this one is clear. Even you, a lay person, and I'm glad you said the Englishness of it. You see, so if we are not, indulging in semantics, it is clear that the moment they filed their nominations, they had hesitated, and it is not for anyone to make any pronouncement because the Constitution has already made a pronouncement. Look at the opening words of Article 97. Yes, look at the opening words. Read the opening words of Article 97.
A member of Parliament shall vacate his seat in Parliament
if a member of Parliament shall vacate.
So shall is immediate. So the very day they acted.
The moment you did this, you shall vacate. It's not the Speaker. It is the Constitution that has, laid the bed for them. Before you lie in it, now if you don't want to lie in it, don't do ABC.
So why did Madam Chief Justice give a futuristic ruling? She said it can only be applied if...
Yeah, it was a moral struggle to find something, and for me, I found it very, very, very distasteful and unacceptable that something that was not there, the majority attempted, to import their understanding into an otherwise clear, unambiguous word, plain, which defied any interpretation. And again, this is where people, will accuse them of, losing confidence in the court. You see, clear. It's as clear as broad daylight.
Well, that's an interesting one for me. In wrapping up, I just want to take your thoughts on this. We have an election coming up. Unfortunately, the last 2 elections, when they were over, have ended up in court. We cannot have a third. But if it ends up in court, what is the guarantee that the party that will take the case to court will get a fair ruling? Especially if the opposition loses.
In the face of or in the light of what has happened, I think now Ghanaians are yearning that in such an all important constitutional matter, the Chief Justice, together with the most senior justices of the court, should sit, and Ghanaians should demand that in empaneling, it shall be the Chief Justice, because the Constitution says the Chief Justice and therefore if she says no problem. But you recall that former Chief Justice Georgina Wood in several constitutional cases excused herself. She didn't sit. She allowed the Atukubes and the others to do it because, as Chief Justice, you have the last and the most, say in such matters. So, take a back seat and give the opportunity to that. If there's a need for a tie to be cast, then the Chief Justice can come. So, I would suggest that should we have another electoral dispute before the court, the Chief Justice and the most senior justices of the Supreme Court, so should sit and not leave it to the genius to create any impression that they are there to thank the president who nominated them.
Okay.
Let's do away with that, this thing. Let common sense prevail.